when we're thinking about supervision orders, I think it's probably, well, I know for many of our parents, it's the least one we talk about, I suppose. But when a parent comes and they've received notification that there's going to be a supervision order hearing, what exactly is a supervision order?
Sure. So a supervision order is an application that's brought to the childcare courts by the Child and Family Agency that, if it's granted, it permits the Child and Family Agency, so allows social workers to visit the child periodically, so from time to time, to allow them to satisfy themselves of the child's welfare. So to make sure that the child is safe and is doing well. And then also it empowers them to give advices and support to the parent as well. So it's a means of protecting and assessing the child's welfare while they remain at home with their parent.
And is there a certain threshold that would need to be met in order to get a supervision order?
There is, yes. So the threshold to grant a supervision order is in theory quite high. It's almost the same grounds as an interim care order.
Okay.
There has to be reasonable cause to believe that a child has been assaulted, ill-treated, neglected, or the health development and welfare might be has been or may be avoidably impaired if a supervision order isn't granted. So it's still quite a high bar. It just doesn't have the serious draconian impact that an interim care order would, where a
Mm.
child is actually removed from a parent.
Yeah, because I was just going to ask there if it's nearly the same level as an interim care order, what is really the differences for a family?
Yeah, so it is a less interventionist order. So it doesn't have as big of an impact on a family as obviously an interim care order would. And it's still a very serious order, and there's potential consequences, criminal sanctions, if a parent were
Okay.
to fail to comply with an order. So if you were to prevent the social workers from visiting the child, or if you were to frustrate it, there's a potential that you could be found guilty of a criminal offence,
Okay.
fined, and potentially imprisoned. Now, the reality is that never really occurs if a supervision order is not working, if the parent isn't cooperating. What usually follows is the Child and Family Agency would issue their interim care order application, that they would say, we've tried the less interventionist order of a supervision order, didn't work. Now we've had our hands forced and we need to go for an interim care order.
Okay. And say for court proceedings, if a family has been working with the Child and Family Agency, TILSA, and but up to this point there's been no court involvement, is the supervision order always the starting point for a family?
No, so the Child and Family Agency aren't obliged to look for a supervision order
Okay.
or applying for an interim care order. It's just something that, as a parent, if you find yourself on the receiving end of an interim care order, you might suggest that a supervision order would suffice. And
Okay. And would that be through your legal representation, Stephen?
yeah, so any parent, any respondent who's been served with legal proceedings should, in the first instance, apply at their closest law centre for legal advice. You'll meet with your solicitor, who'll advise you of, the nature and consequence of any applications that's being made, so supervision order or interim care order, and then we'll assist you preparing your defence and try and see can any alternatives to these applications going ahead be agreed and worked out with the CFA.
Okay, that's really interesting. And like if I'm a parent and I've attended court and the supervision order, the threshold has been met, the supervision order has been granted by the judge, there's normally a number of conditions which you've mentioned there that the social workers will call, maybe announced unannounced visits to check. They may do welfare checks, but there may be other things like intensive family support, or that the parent received um, maybe some other various parenting supports or substance misuse services or mental health services, will the specific agreement for that family be written into the order?
Well, usually no, because the supervision order, all it does on its face is allow the social workers to visit the child, as you said, announced or unannounced. The judge can, alongside a supervision order, make some directions, but it's actually very limited in terms of those directions that can be made. In making a supervision order, the only directions the court can actually make is that a child is to be brought to any particular medical assessment,
Okay.
psychiatric treatment. The court actually, alongside a supervision order, can't make directions that the parent, do something positive, that the parent undertake an assessment, that a parent enter into treatment. The court actually can't make that direction. So that is the kind of downside to supervision orders from the social worker's perspective, in that it's a little bit toothless in that regard, because it can't compel a change that they might believe is necessary. All it does is allow them to visit the child.
Okay, interesting, because I think that's a misunderstanding that's out there, that there's normally a list of kind of recommendations essentially, but that are part of the actual order as well. A lot of parents would think they are part of the order.
I think the reality is that in looking for the order, the social workers would tell the court of all of their concerns and the steps that they believe need to be taken to address those concerns. So while it doesn't form part of the directions, it's very clearly, the grounds, the basis for the supervision order. And a parent would be well advised to try and take steps to address those underlying concerns, because again, if they don't, there's always the threat of the even more serious application, such as an interim care order.
Yeah. And how long does a supervision order last for, Stephen?
So a supervision order can be granted for a period of up to 12 months.
Okay.
It can be granted for any period of time. Shorter than that, the shortest that might really be sought would be 3 months. 6 months might be a common time frame, because the Child and Family Agency might reach the view that this is the warning shot that, progress is going to be needed to be made. And if not, then, it's not a supervision order that ultimately will be required.
Okay. And if can a supervision order be granted more than once?
Yes, so there's no provision to extend a supervision order, but they can apply for fresh supervision orders once one expires. So even though a supervision order can only last for a period of 1 year, there's nothing to stop the CFA coming back at the end of that to look for another year, and indeed another and another.
And would that be something you have seen? Is it unusual or is it a common practice?
It'd be unusual for a supervision order to go on certainly beyond 1 year, realistically. The reality is that either concerns have been addressed or they haven't. The supervision order has been complied with or it hasn't. That there's unlikely to be a benefit to supervision orders going on for beyond a year, although it could conceivably happen.
Okay. So how does a supervision order then, it naturally gets discharged, or if parents have started doing really well and the concerns have dissipated, can a supervision order be discharged in the courts, or does it naturally have to run its length?
It can be either or. So the supervision order, as you said, runs its course and it expires, or the Child and Family Agency are of the view that it served its purpose, it's no longer necessary, could apply to court for its discharge. But that itself is quite unlikely. So where even tremendous progress has been made and maintained, the CFA would say, well, there's no harm in leaving the order in place. We just don't need to use it, and we'll let it run its course and expire.
Okay. And if a order is in place for a family, is there any number of visits, like a set number of visits that they can expect, or it can be as regular as daily, weekly, monthly, or it shouldn't exceed a certain number?
So there's no set amount. The order would provide effectively for as the agency deems appropriate. Now the reality again is that social workers tend to work Monday to Friday, 9 to 5. It's most unlikely that you'd be getting visits outside of those hours, other than maybe the occasional Garda welfare check or an out of hours check or something. But by and large, it's not going to be outside of Monday to Friday, 9 to 5. And there's also provision in the Act that if a parent believes that the agency are being overzealous, if they're conducting what the parent thinks is too many visits, the parent can bring the matter back to court and look for
Okay.
directions as to the appropriate amount of visits and methods of visits.
Okay, really interesting. And does it have to be the social worker allocated to the family or allocated to the child, or can it be different social workers at different times, or could it be in some instances social care workers or other professionals working with the family?
So the order empowers the child and family agency to cause the child to be visited. So that's a good question. It's not crystal clear on the face of the law, but you can reasonably assume that yes, any employee or agent of the child and family agency is covered by the order, and a parent then really should permit them to visit the child as appropriate.
Okay. And just where you were saying there, if things escalated in the family, particularly maybe at the weekend or over different periods, such as Christmas, it may be a Garda welfare check or out of hours social workers check, for some reason, and there was clearly identified risks there, what would happen then? Would they need to wait for a further hearing around the supervision order, or?
No, so the making of a supervision order doesn't preclude or stop the child and family agency from bringing other applications that they might deem necessary. So that might be an emergency care order, it might be an interim care order.
Okay. So if I'm on a supervision order for 6 months, my family's on a supervision order for 6 months, and things aren't going too great, and new concerns have come to light, um, TUSA may bring an application for an interim care order before the 6 months is up.
Yeah, absolutely. So they can bring that application at any stage, and TUSLA are statutorily obliged to bring an application to court if they believe it's necessary and appropriate. So even though there's a supervision order in place, if circumstances change or if their assessment alters, they're obliged to bring an application to court if they think it's necessary.
Okay. And if that happens, does my legal cert that I have that covers me for the supervision order, will that cover further proceedings as well, or new applications?
So that might kind of vary from circumstance to circumstance. By and large, if the legal aid certificate is in place to defend childcare proceedings in the district court, it should cover the same application, assuming it's concerning the same children.
Okay. Okay. So there might be nuances there for parents that they may have to, by and large, it will cover it, but they may have to make new applications. So they should really contact our law centre once.
If there's any, as ever, if there's any suggestion of childcare applications being made to the court, you should immediately contact your legal aid solicitor.
Very good. And we won't go into all the emergency orders or interim care orders because we're going to dedicate um, other webinars to exploring those orders as well. Um, have you seen where parents have had supervision orders in the past, have done really well, and have been kind of a number of years may have passed, or again, a different child would there be patterns of them coming back in for further supervision orders in the future?
It does occur. You would always be hopeful that if a supervision order is made, and as you've outlined, progress was made to the extent that the social workers believed that they were not looking for further supervision orders or more serious orders, you would of course hope that that progress can be maintained and that it wouldn't return to court. I quite often say to parents at the end of supervision orders, don't take this the wrong way, but I hope I never see you again.
I'm sure they feel the same as
Yeah.
well. There's just a question in the Q&A, Stephen, around can a judge decide to issue a supervision order when TULSA has applied for a care order?
Yes, so there is provision under different sections for the courts to grant supervision orders other than on the usual application under section 19 for a supervision order. One of those circumstances is, yes, a court in considering a care order, a full care order application, a court can refuse a care order and grant a supervision order in its place. But interestingly, if a court were considering an interim care order, it doesn't have the power to refuse an interim care order and grant a supervision order in its place. The Child and Family Agency would have to bring that application separately.
Okay. This may be too basic a question, but why is that? If the judge felt the supervision order would be the right order.
I suppose interim care orders are in theory granted pending determination of the care order. So interim care orders are only there and only exist until the care order is determined either one way or the other. And a judge
Okay.
could then say, well, the interim process has concluded. I'm hearing a care order hearing or application, and I don't believe threshold is met, but there are still concerns. So a supervision order is appropriate.
Okay. Oh, it's very interesting, isn't it? It's there's lots of different avenues, and I suppose very complex information for parents to take in, especially when they're hearing names of different orders and things like that. It can be very confusing.
Yeah, absolutely. It is completely overwhelming, for the average person coming into, on the receiving end of childcare proceedings for the first time. So again, it really kind of underscores the benefit to early legal advices. So you understand your rights, obligations, and potential risks and potential
Mm,
applications that might be made.
yeah. Thanks for that, Stephen. My final question today, around supervision orders is really, do the courts keep, obviously, notwithstanding the in-camera rule, so the individual cases aren't discussed or reported on, but do the courts keep any sort of kind of oversight records to see how many supervision orders are applied for versus ICO versus, and is that information available widely?
Yeah, so my understanding is that the court services compile all of that information and it is made available. So yeah, the information certainly is out there and is obtainable. As you said, obviously respecting the in-camera rule, so the
Yeah,
names of the parties are never disclosed, but the sheer numbers of applications are kept, yeah, and is available.
great. We have another Q&A here. Just let me see. No, we've um, are supervision orders underutilized in comparison with care orders? And if so, why might this be?
I think, yeah, there's certainly a good argument to be made that they are underutilized, and I think that might be because of this kind of toothlessness that I described earlier, because all it does is empower the Child and Family Agency to visit the child. It can't compel change and improvements that the CFA might ultimately believe are necessary. But in the last couple of years, we are seeing an increase in the number of supervision order
Okay.
applications. And I think that's actually a reflection on the current placement crisis that TUSLA has. So TUSLA can be working with a whole number of families where they have significant concerns and ultimately feel that an interim care order may be necessary, but don't have placements. And their only option then is perhaps to give more consideration to supervision orders and putting in place supports as well. So we are seeing an increase in supervision orders. And I think that's a result of the placement crisis.
That's really interesting. Now my mind is working on, is there some analysis to be done there to see if the supervision order and the supports put in place are successful in not proceeding to interim care orders or care order proceedings, or is it just that by putting in a supervision order where there's not possibly placements available, that the risks don't dissipate and they just get, I suppose, the child still ends up going into care?
Yes, so sometimes the Child and Family Agencies have to bring the appropriate application. So quite often they'll believe it may be an interim care order, so they might bring that application. But in circumstances where they don't have a placement, certainly the representatives for the parents may suggest, in place of an interim care order, why don't you now give proper consideration to supervision order in its place and put in place robust supports? And then hope, yes, that does ameliorate it, that does improve circumstances to the extent that they might be satisfied to withdraw their application ultimately.
Okay. Really interesting, isn't it? And it's interesting how resource issues can then impact court proceedings as well. So, and how the two systems interface as well. So, um, there's no more questions in the chat, Stephen. Oh, uh, yeah, just a comment around fascinating discussion. Many thanks to you both. So, and very helpful information. I think it's so useful to be breaking down what these terms actually mean and what is understood, what the actual power is versus what the understanding of the power is as well, and then how we all work together, I suppose, for the best interest of the child as well. Thank you so much, Stephen. And I'm going to just put up a slide now in relation to our feedback form, and also our webinar next week is around emergency care orders, which we touched on today, but we'll be going into in a little bit more detail around what is an emergency care order, when they happen, and what it looks like in the court proceedings. Thanks so much, Stephen.
Great. Thanks very much, Niamh.
Thank you so much to everybody for attending today, and thank you for your patience with our late start. Thank you so much, and look forward to seeing you next week.